to introduce our panel and begin our discussion, I'm going to turn the podium then over to Dick Jackson, who is the dynamic new chair of our Liber Society. So, Dick.
Well, I don't know how dynamic I am, but I was just recently elected as the chair to the Liber Society Interest Group, and our purpose, nested underneath the American Society of International Law's purpose, is to disseminate information and assist in the teaching and dissemination of the law of armed conflict, or the law of war, also known as international humanitarian law. And so this is a great opportunity to talk about this area of the law that is of such interest to the Liber Society and ASIL. I really want to thank Paul Kong, who's in the back of the room from the ICRC, who really proposed that we do this today and is co-sponsoring this event. The ICRC is picking up the tab on most of the refreshments, so we really appreciate the ICRC's help in putting this together. Which leads me to our panel. We have first Gary Solis, whose military experience and post-military experience as an expert in international law and the law of armed conflict is almost unparalleled. He's the author of several books on the law of war as applied by the criminal law, particularly in the Vietnam era. He has taught at the United States Military Academy on two different occasions for a long period of time, developed a number of curricula, not only in the law of armed conflict, but seminars on issues like torture and the unlawful combatant and how they should be treated on the battlefield. And over the years has also been an adjunct professor at Georgetown University Law Center, my alma mater, and it has been teaching the law of armed conflict there. Jamie and I'll have more to say about the book when Gary gets a chance to speak. But the second person on the podium here is Jamie Williamson, who is the legal advisor for the International Committee of the Red Cross here in Washington, and a very engaging speaker, very much an expert in the law of armed conflict. We quite frequently spar over these issues in academic settings and even in government corridors, as these topics that are so relevant today are discussed and the policies are developed. And Jamie has a great deal of experience in international criminal law and the law of armed conflict in many areas of the world. So I think you'll really enjoy his remarks. The format we'll use today is Gary will speak for a bit and talk a little bit about developing the book, some of the areas that came to his attention and were really interesting to him in working, and maybe talk about some current examples. Folks, there's some chairs up here too if you're interested, so you don't have to stand in the back. And then Jamie and I'll each take about 10 minutes each to offer our views after reading the book and maybe an occasional critique. And then Gary, of course, will get the final moment to really sell you on the value of this book. And we all believe that it's valuable for not only the teacher but also for as a resource for those that practice the law of armed conflict. So, Gary?
Thank you, Gary. First, gents, ladies, I very much appreciate you taking the time out of your schedules to come here and hear this. I really do appreciate it. I'm very flattered. And Dick Jackson's introduction is... Never mind. And Dick Jackson's introduction didn't mention that Dick, of course, is a retired United States Army colonel with extensive background in international law and the law of war. He's written many articles on the topic, and he is currently, if I'm not mistaken, the Special Assistant to the Judge Advocate General, United States Army for law of war matters. So I appreciate that Dick and Jamie and Paul and you are here. I'd like to tell you a little bit about the book and how it came to be, because, as was mentioned, there has been something of a gap in the law of armed conflict in that the U.S. does not have a textbook per se. This is a law school textbook, which I hope will carry over to upper division undergrads for either a semester-long course or a course module. It's written both for students and for the instructor-professor. For students who have no prior knowledge of the law of armed conflict or international humanitarian law, as many of you may prefer to call it. That's virtually all students. For professors, in that some professors may not have taught the subject before and are not yet comfortable with designing their own course, and hopefully the book will help in doing that. I'd like to stress that one does not have to have any military experience to use this book. It is, of course, written from a military perspective. I'm a retired lieutenant colonel in the U.S. Marine Corps in my previous incarnation, and I went to school and got plussed up on the law of war at the London School of Economics and have been teaching the law of war for the last 15 years. A little bit about the genesis of the book. I came to the United States Military Academy at West Point in 1996, and I asked who taught the law of war. I was told we don't teach the law of war here. West Point, we don't teach the law of war? No, we don't. Of course, it has been taught in the past, and there are pieces of it here and there, but there was no single course. And so I determined to teach that course, and after almost a year of shepherding the proposal through the various committees at West Point, started teaching it in early 1997. A course at West Point is 40 lessons long. There are 2 exams, 2 reading days, 1 holiday. So I had 35 hours to fill, and I had no idea how to do it. I looked around for a textbook and found none. So I wrote down every law of war topic I could think of and made them the 35 hours. And there was a lot of Xerox material that year because there simply wasn't any textbook that I could find that covered the ground. My textbook was FM 27-10. That's why Hayes Parks isn't here today. He's still working on his new one. But the 1956 27-10 became the only book that I could find that was close to it. And I should apologize to my West Point cadets because for the first 2 or 3 years that I taught that course, what I didn't know about the law of war would fill a freight train. Well, my teaching lacked coherence. There was no overarching organization, no thematic progression, no guide as how to proceed through the various topics in the law of armed conflict. Yes, we've all taught topics that are new to us, but usually when we do so, we find that there are notes from a previous professor or a book in the area that's respected and is commonly used, or something. But there was nothing in the law of armed conflict. So over the next 6 years, I used first L.C. Green's book. It's a nice book, but it's fairly disorganized. So that lasted about a year. Then I used Tony Rogers' book, which is very good, but it's a bit here and there too. You go from here on the subject, then to there on the same subject, and so forth. So after that, about 2 years, I moved to Jorm Dinstein's excellent book. But as you know, if you've taken a look at it, it presumes one already has a fairly sophisticated knowledge of the law of armed conflict, and he doesn't handle Common Article 3 conflicts at all. So for years at conferences, seminars, meetings, a frequent complaint is that there was no good basic LOAC textbook, and that's the gap that this book seeks to fill. I'm not here to sell books, because as you know, nobody gets rich from buying or selling textbooks. But I am here to let you know that if you're interested in the field, there now is a basic textbook for students that professors and instructors can also use. How good it is, I'll leave it up to you and the reviewers. But by the time I taught LOAC, IHL, for 10 years, purely through trial and error, I saw that there was a progression. There was a thematic thread through the topic. So how do you teach the law of armed conflict? Well, it's really pretty simple. It's almost simplistic, almost embarrassingly simple. First, you determine conflict status. Then you determine individual status, then in my case at least, you go through the 4 or 5 core concepts of distinction, military necessity, unnecessary suffering, and proportionality. And you have essentially the framework for your entire semester. You then, as an instructor, can add to that anything you want. But once your students have the conflict status, individual status, and understand things like proportionality and distinction, you have the core of the law of armed conflict for any semester or any module. So, that's the instructional arc that organizes my book. It's a textbook for classroom use for professors who can riff off the content. It's for those who want to start classes with a clip from today's newspaper. It's for those who want to attack accepted IHL wisdom. And I try to provide you, the professor, the ammunition to do that in the textbook. One of my first questions is, what title? I mean, in the military, we call it the law of armed conflict. Most civilian professors call it international humanitarian law. Well, I combined them both, the law of armed conflict, international humanitarian law and war. Is there anybody I missed? So, I didn't know what to call it. Should it be a textbook or a casebook? If it was to be a teaching text, it had to be a textbook, I thought. But as you know, LOAC is rich in cases, particularly today with the ICTY work that's been so terrific for LOAC, for IHL. I mean, we have the subsequent proceedings, those 12 opinions, and of course Nuremberg and so on. So the book employs 240 cases. Now, most of those cases are only passing references, but 52 of them are traditional case cuts. So I tried to bring in a number of cases as well. And they're current. There are a number of 2008 cases and several 2009 cases, mostly from the ICTY. Cases were added up until the very final edit. As a matter of fact, the 2009 ICRC concept of direct participation in hostilities, we call back the final proofs to add that in to the chapter because I felt it was so important that we get that in. I didn't want to wait till a possible second edition to be talking about DPH and the ICRC study on DPH. Footnotes or endnotes? Well, that was easy. Footnotes so that the student, if she wishes, can immediately read amplifying information and find additional sites to deeper, further explanations of whatever she may be reading. So there are 2,400 footnotes in the book. Reader interest. Now, in a prior incarnation, I was the U.S. Marine Corps Deputy Chief of History. And my first book was a military law history. And we all know from our classroom experience that nothing jacks up an academic topic like a good example, maybe from combat. At West Point, we found that cadets really liked examples from real life, combat stories, The Great Escape, current cases from today's newspaper that they'd all talked about with other cadets. So examples play a major part of the text. And I hope that they add interest not only for the student, but for any reader, including the professors. I intended to have sidebars with colorful examples isolated in shaded boxes. Well, that doesn't work out so well when your typesetter's in New Delhi, India. So all that survives are shaded boxes right in the main text with a sidebar up there in bold letter. That's okay, it works. So that turned out all right after all. It's sufficient. And some of the best stories are in the sidebars. You know, there's the one-armed Civil War general, General Philip Kearny, who, before the Civil War, had been retired because he'd lost an arm in Mexico. He went to Paris to live. He got to know Napoleon. And when Napoleon went to war in Italy, he importuned Napoleon to let him fight with the French forces. And he went to battle in Solferino, wearing his U.S. Army uniform, and was the first American to be awarded the Legion of Honor. Isn't that cool? So that's a sidebar. That is a sidebar. Or the American who, prior to World War II, he was from La Jolla, California, joined the French Foreign Legion. And for 5 years, he fought first Berbers and then the Nazis. Was seriously wounded. The U.S. entered the war. He returned to the U.S. and enlisted in the U.S. Marine Corps. When he told them what these ribbons were, no one believed him. And so he finally was recognized, and he was sent to officer school. He was seconded to the OSS, and he was several times parachuted behind enemy lines in France, where he led OSS teams. And what's terrific about Philip Ortiz is that he wore his full U.S. Marine Corps uniform the entire time he was behind the lines in Germany, in France. His entire uniform, under an overcoat. I mean, with the blouse and the tie. Amazing. One time in a bar, this isn't in my notes, but one time he was in a bar and he heard two Germans bad-mouthing the U.S. He threw off I'm not making this up. He threw off his overcoat, pulled out his .45, made them stand up and sing their version of America the Beautiful, and then the Marine Corps hymn, which they had no idea about. And then he ran away and got away. Well, he was awarded 2 Navy Crosses and several Purple Hearts, and 2 movies were made about his life, including, you may have heard of 13 Rue Madeleine with Jimmy Cagney. Anyway, sidebar. All right. Another sidebar is Omar Cotter, who we all know about. Confined in Guantanamo for 8 years, subjected to the frequent flyer program, by which he was transferred from cell to cell every 3 hours for a month. In a 2-week period, he was forcibly moved 112 times. Is that torture? That's in a sidebar. So these are examples of efforts to make the text interesting to the reader, to the professor as well. The text tries to draw the student into IHL, issues large and sometimes small. For example, I believe that until the ICTY, the 12 subsequent proceedings at Nuremberg are the high watermark of the jurisprudence of the law of war. Those 12 decisions. And yet very few students know about the subsequent proceedings. And so I have a large section on the subsequent proceedings. And, well, if I can read to you for a moment. Following the Nuremberg IMT, the United States initiated a series of war crimes trials in its sector of Berlin, as did the French, British, and Russians in their sectors. Referred to as the subsequent proceedings because they were subsequent to the IMT in purpose and method, the trials were based on a 1945 Joint Chiefs of Staff directive and generally parallel the IMT's procedures and rules. The proceedings implementing directive was Control Council Law Number 10, a reference to the Allied Council that oversaw the governing of Berlin, eventually totaling 12 U.S. trials. An aggregate of 191 high-ranking military and civilian Nazis were tried in the subsequent proceedings, and so forth. And then for the next several pages, I go over that. And, of course, I had decisions in writing to make should the book deal with such passing issues as, I hope it's passing, enemy combatants and unlawful enemy combatants. They'll remain in the news, and therefore student questions as long as military commissions are in the news. And so ultimately I decided to deal with those topics. Although not military commissions, I had a lot of material, and I've written on military commissions, but it's such a fast-moving target that I felt anything that I wrote this month would be superseded next month. So there's nothing in the book about military commissions. Nothing directly, anyway. So there are a few issues that I'd like to mention to you, but before I do...
Well, the good lawyer reserves for his rebuttal his best argument, so I'm sure Gary will give you some of those in a few minutes. But I really want to start by praising this book. I've studied the law of armed conflict. I've taught the law of armed conflict at the undergraduate level and at the graduate level. And as Gary said, now it's my day job, and in some ways it's my night job too, with ASIL and the Liber Society. I need to start by saying that anything I say here that has nothing to do with my day job, that I'm speaking for myself personally, not for the U.S. Army or the Office of the Judge Advocate General. But I want to start by saying that Gary's book is an excellent teaching resource, and from both my experience but also from digging into it. The substantive law is laid out, as you've seen already, historically and logically. He takes interesting and provocative cases, and some are obscure, but all are relevant and fascinating. An example is the last Indian combatant from the Indian Wars, and the case that clears him from a charge, a war crime charge, essentially, because he was a combatant and carried with that the belligerent's privilege or the combatant's privilege. He's got in there topical and thought-provoking applications and questions about the law of armed conflict. And it's the law that's a law of war that's relevant to today in this world of non-state actors and asymmetric tactics, a very complex and engaging law. But and I think you can see from Gary's enthusiasm for this topic in the law, but also from our description of the book, that students will really catch fire with this type of presentation of the law. And I think that's true both at the undergraduate and graduate level. I'd like to offer a few critiques, though. One is the use of Army manuals. At one point, Gary says, and he's quoting the Judge Advocate General's Legal Center and Schools teaching materials as saying that the Army JAG says XYZ, which the Army JAG doesn't prepare the teaching materials. It's guys like me who was assigned there as a lieutenant colonel preparing teaching materials. So that's not really Army policy or the policy of the U.S. government. It's a good example of the kinds of issues that are being taught, but not necessarily the policy of the Army. For example, too, he's what I'd say a little too gushing and inaccurate in describing the role of the International Committee of the Red Cross. One quote is that the ICRC is the enunciator of international humanitarian law. I'd say that word would really please Jamie, but it's not true. The law of armed conflict, or IHL, is defined by states, generally through treaties or through customary international law. And second, that the ICRC forms a very important role as the public oversight of military actions. Well, I'm sure Jamie will tell you, or Phil, who's in the audience, who used to work over there, will tell you that the ICRC's relationship with states and, quote, oversight of military actions is a confidential one. So the ICRC doesn't get in the mode of publicly criticizing states' parties' actions. I think Gary could have presented both sides of the issue, maybe with a little bit more of the U.S. position. For example, and I'll just take one, the U.S. position on Additional Protocol 1. Gary goes into great depth about discussing the pros and cons of Additional Protocol 1, but most of it focuses on the adoption of the standard in Article 1.4 of including insurgent groups that are national liberation groups as a party to the conflict of a international armed conflict. Well, most of the U.S. objection, and the place you find this is in President Reagan's transmittal of Additional Protocol 1 to the Senate for non-ratification, and in both Aldrich and Sofer's remarks shortly after the negotiation of the 77 protocols about the U.S. objections. The U.S. objections are mainly based around the risk that additional Protocol 1's watering down of the distinction principle poses to civilians. And that's a very principled and the prominent reason why the U.S. government has not and probably will never ratify in whole additional Protocol 1. There's a couple other areas that I think the book could blend jus ad bellum and jus in bello a little bit less, and maybe make it clear that there's a distinction between the law for use of force and the law of armed conflict. The definition of war crimes is something that we might talk about further in questions and answers, because that's a fascinating area of this and of the book, and the book is very good in getting into substantive war crimes and international criminal law. I take issue with the term, and Gary and I have talked about this before, and also I've seen Gary speak about this topic of targeted killing. I take issue with just the nomenclature of targeted killing, because we don't engage in targeted killing. We target military objectives or combatants. Targeted killing connotes some sort of assassination, which is not the case in armed conflict. Okay, those are some minor criticisms. I think this is a great resource also for research and background on the law of war. I plan on having this. This is my copy. I plan on having this in my bookshelf and as a constant resource material. So it's a great book, and he told you about the footnotes and the case sites. Now, it's not only obscure cases, it's some of the most important cases of the last several years from the ICTY, the ICTR, that really have written the law of armed conflict since 1994. So those are fantastic. And the footnotes go back to areas that I want to do research on. I mean, and I practice this area of the law every day. I want to go back and read some of the footnotes he's got in here. As I said, it's meticulously researched. The references are a great place to start if you want to go into even more depth. And I think the greatest feature of this book is its mixture of criminal law, international criminal law, and the law of armed conflict. We at ACIL have two separate interest groups, really three separate interest groups that deal with the issue of international criminal law. We've got an International Criminal Tribunal one and an International Criminal Law interest group. But those three interest groups really are all about the same subject. It's about the crimes against humanity, the war crimes, genocide, these issues of mass atrocities and in internal armed conflicts that result in criminal prosecutions. And Gary, with the eye of an historian and the sense of a professor that wants to really engage his students, has taken these cases, integrated them into an exposition of the law to make it really a great resource and teaching material.
Thanks. Again, I'm speaking in my personal capacity with regards to my day job. I don't have a night job. I have a 2-year-old child, but that's about it. I don't have much more to add to what you've already said, Dick. In terms of the gushing with regard to the ICRC, if we can come back to that in a second or two, but I think those quotes are actually pretty good. And there's a couple of other areas in the book where you have references to the ICRC and some of its work, which we'll come back to in a second, which I think are pretty nicely balanced, the DPH aspect, which I think is pretty good. I took it from a book, from an angle in terms of someone who's working in this particular field, someone who's come from an international criminal tribunal background and now with the ICRC. And also a book which I wanted to have something which was handy and fanciful, and something I could carry around with me. I think the problem with many case books these days and case of materials is that they're that big. If you want to try and put everything into something, it's either a CD-ROM, but we don't necessarily have our computers with us, or it's a 600-page book, and I certainly don't want to carry that with me wherever I go. And that's why, hats off to Gary. I don't know quite how you managed to get everything into this book in that many pages. But I think that's, for me, first thing is size. I mean, it's a practical book to have. The ICRC keeps talking about its customary law study, which is a fascinating study, and all its materials there, but volumes 2 and 3 are seriously bookshelf material. So unlike you, Dick, it won't be on my bookshelf. I do carry this book around with me in my sort of briefcase, simply because I think it's quite useful to go back to, in particular because of the rich diversity of cases that you have in your materials. You've written it in a way which I think is going to make it interesting for both students as well as practitioners. I rarely go back and say to individuals, I picked up a case book or materials, a law book, and read it. I just don't read those kind of books. I go back and do some research and say, okay, that's interesting, and put it aside. But actually, I have taken your book and tried to read it, and I found the narrative to be fantastic, and the way you bring to life many of these cases. And it's not just the sort of historical going back 100, 150 years or more in some of the chapters. It's more the fact that you also take in today's cases, some of the ICTR cases. And I think for a number of the practitioners in this room who've worked with the tribunals to have some of your sidebars, looking at, for instance, the ICTR cases, which I think have as much weight to give as ICTY cases when it comes to certain war crimes issues, it's fascinating, and it sort of brings back good memories. You have a very good sidebar with regard to the Akiyesu case, the first case at the Rwanda tribunal, and the question of sexual crimes. And the way you present it is less in terms of the legal aspect, but in terms of the way the witness brought the issue forward, and then the judges took it one step further in terms of, well, there were rapes going on. Why is it that no one raised this before, and neither the prosecutor nor the witness until the witness was pushing these issues? But you bring that to life and show the other side of, and I think the life of criminal procedures. I think, for the most part, it's fairly objective, and you tend to put both sides of the coin in your arguments. And I think your enthusiasm, as Dick was saying, can be seen in the way you write. I mean, it's interesting, it's exciting, and there are many issues there which I think are worth further debate. The gushing aspect, I would say, he is gushing about the ICRC, certainly, and there are some things to be gushed about, if we can say that. And I think what is good is that you are up to date. As you said, for the DPH study, I think you must be the first author in a case book to actually have a section on the DPH study. The fact that it's come out in 2009, I don't think there's any other case books that have come out looking at DPH. And I think what is nice there is that you have stuck your neck out a little bit by saying it's a good study and a good guidance, but at the same time you've reserved a little bit of the imperfection element and said, well, maybe it's not so good afterwards, excuse the hand movements, but I think that's how you do it. And I think I just take two quotes from there, and I think one will please DOD and the others who are not necessarily totally in favour of the DPH study, and the other one will actually please the ICRC, despite the fact that you do refer to it as not being so perfect. So the first statement is, the DPH study gives unlawful combatants opponent guidance that offer significant targeting latitude. I think for some, especially those who are involved in the targeting business, that will be seen as good. It seems to suggest that we go a bit beyond than the normal. But for the ICRC, it may be read as being, oh, no. We didn't actually want to give that kind of latitude. We actually come in from a very protective approach and making sure that individuals are protected to the fullest extent of the IHL. But it's nicely balanced. And similarly, on the same page, you have the question there on, although not perfect, the report provides a clarity previously absent. Given the back and forth between a number of academics and experts as to the contents of the guidance, and given that it's taken 6-7 years to hear the word clarity being used to describe the DPH guidance, it's hats off, and I tend to agree with you in that regard. But all I'll say, I mean, the chapters I looked at specifically were the war crimes questions, especially from the international tribunals aspects, and the questions of command responsibility and respondent superior. I found those two chapters particularly interesting because they're up to date, and you bring out ICTY, ICTR, Nuremberg, and previous jurisprudence before the World Wars that were relevant. So I will gush back towards you and say, well done, hats off. Good luck with the supplements, because you do have, I don't think you're talking second edition necessarily, because you do have a number of issues here which are still moving. So I think the follow-up would also be very interesting to keep it up to date. Good.
Thank you, Chairman. My mother'd like to say a few words. There were a few issues that are in the book. Some covered okay, some not so well. Not well, for example. I wish now, the book was 2.5 years in the writing. And I wish now that the text was more clear on what I see as the fading significance of the Common Article 2, Common Article 3 distinction. It seems to me that that distinction is fading rapidly. We don't have prisoners of war in Common Article 3, but we do have war crimes and grave breaches in Common Article 3, armed conflicts. I think in 5-10 years, that distinction will be going the way of Geneva law, Hague law distinctions. Another thing done not as well as I would have liked is the discussion of war crimes. What constitutes a war crime? I respond to that question by providing definitions. But what is a war crime? Of course, grave breaches, ICC Rome Statute, Article 8. But, for example, what if a Taliban fighter in armed conflict with U.S. forces in Afghanistan shoots and kills a U.S. soldier? Now, if we capture that individual at Guantanamo, we're charging that as a war crime. Is it? Is it? Is inclusion in the amended Military Commissions Act sufficient to make it so? Well, what is it that makes an act a war crime? How does the U.S. support the viewpoint that that is a war crime? Is that not a domestic crime under Afghani law? Well, we say it's a war crime. Well, if it's a war crime, how so? And it's not just that situation, but in any situation. How does a war crime become a war crime? And I wish I had delved into that more deeply. Reasonably well. Unlawful orders. What is an unlawful order? Texts in the past that I'm familiar with haven't gone into that much. How is an unlawful order recognized? I try to provide some examples. I try to define what an unlawful order is, although predictably the definition simply substitutes a new set of undefinable terms for the original set of undefinable terms. But what should a soldier do upon receiving what she considers to be an unlawful order? What are the dangers of refusing to obey what one considers an unlawful order? Can officers disobey unlawful orders? I try to answer those questions. I'm fairly satisfied with that section. Rules of engagement. ROE are widely misunderstood, and frequently cited where they're not really appropriate. Even soldiers who have the little pocket cards don't always understand what ROE are. They think that the ROE are what's on that little pocket, not appreciating that that's a distillation of a 20, 30-page order that came down from the Joint Chiefs of Staff after consultations with the commander on the scene. Rules of engagement are not tactical directives. Well, we took down the house according to the ROE. No, you don't take down a house. You don't attack a position in accordance with the ROE. The ROE give you direct. The ROE are the tether from the commander to the individual soldier on what he or she, when he or she may use armed force. They're not a directive on how you carry out a mission, how you execute a mission. So I try to give some background of where the ROE came from and what their intent is and what they actually are. I use a real-world example of how a commander at sea who's going through a NEO. A NEO is non-combatant evacuation operation. How the commander at sea radios back and forth with the Joint Chiefs staff in Washington to come up with the ROE, etc., so that the student will have a better understanding of what they are. Targeting is an area that came out reasonably well. As one who, I've had an active interest in targeting, and so I'm aware of the many safeguards that are involved in any fire mission. And I think the public is unaware. They just think, well, we just fired a gun. That is not how it goes. Oh, drop the bomb. No, that's not how it goes. There is a real process, a very convoluted protocol for firing above the soldier's level, above the single trigger puller's level. And I try to make that clear to the student and to the reader. So as a LOAC professor, I also have an awareness of how those safeguards go awry. So, in that chapter, we cover dual use targets, collateral damage, dangerous forces, indiscriminate attacks, targeted killings. They're all covered in that chapter. Let's see. I have a sidebar on page 527. One moment, please. Oh, yes, targeting. Can a civilian passenger airliner be a military object and a lawful target? At 0846 on September 11th, 2001, Al-Qaeda hijackers flew American Airlines Flight 11 into the North Tower of the New York City's World Trade Center. At 0903, other hijackers flew United Airlines Flight 175 into the South Tower. President Bush was visiting an elementary school in Sarasota, Florida. In Washington, Secret Service agents hustled Vice President Richard Cheney into a shelter deep under the east wing of the White House. American Airlines Flight 77 and United Airlines Flight 93 were known to still be speeding in the direction of Washington. Sometime between 10:10 and 10:15, a military aide asked the Vice President a question regarding Flight 77, with 64 passengers and crew aboard, and closing on Washington, D.C. Quote, the jetliner was presumed hostile but packed with innocence. Should the Air Force shoot it down? Cheney paused. Then he answered, I'll have to read the book. He answered yes. Of course, there are many questions. Did he have the authority to do that? Was there an armed conflict in progress? Where did this authority come from? A targeting issue. Did he have at that time the authority to make targeting decisions? Well, last Saturday night's Times Square bomber, Faisal Shahzad, was captured on Monday night. What is his status? Is he simply a federal prisoner? Well, Senator Christopher Bond from Missouri, the ranking Republican on the Senate Intelligence Committee, urges that we should be more concerned with gathering intelligence than with rights, as does Senator McCain feel. Although Shahzad is a U.S. citizen, Representative Peter King urges his trial by military commission. Senator Joe Lieberman suggests legislation stripping U.S. citizenship from those connected to foreign terrorism. So is this gent an unlawful enemy combatant? Can he be an unlawful enemy combatant, a term no longer in favor, of course? Or is he simply a detainee? He's certainly not a POW. His status, I think, is really fairly easy. He's simply a prisoner in our domestic legal system. But what is the conflict status of the war on terror? Well, that's something we can talk about. So there's considerably more in the book, of course. I'm very pleased with the chapter on torture, to include waterboarding, and a very lengthy quote from one of the CIA's 4 top-secret torture memos. I'm going to read the close of that. On torture. I'm sure I was as appalled as you were when you read those memos. After 3 pages of quoting from one of them where they lay out the 30-day program for beating the crap out of somebody that they want to interrogate, a country is what it stands for when standing for something is most difficult. One can only wonder what Supreme Court Justice Robert Jackson, Chief Prosecutor of the Nuremberg International Military Tribunal and former Attorney General of the United States, would say upon reading this document. His wrath at the perversion of American justice and ideals. What would he have responded to the tired argument that it was all for the protection of Americans? The April 2009 release of this document, signed by Stephen Bradbury, Principal Deputy Assistant Attorney General, Department of Justice, along with 3 other torture memos, was controversial. Mr. Karl Rove, Deputy Chief of Staff to President George Bush for 7 years, on a televised talk show, encouraged Americans to read the memos saying, quote, "You'll be reassured about what your government is doing." Mr. Rove continued, all of these techniques have now been ruined. One can only hope. Well, sometimes, one time a couple of years ago at Georgetown, one of my students said to me, well, it's obvious that you're an Obama Democrat. And I said, no, I'm a lawyer and I can read the law. And that's the approach I try to take in the book. So, there are other chapters, of course. There's cultural property concerns. There's gas and biological warfare. The 1980 Chemical Weapons Convention is covered. The Conventional Weapons Convention is covered. The Ottawa Treaty on Landmines is there. 2008 Dublin Convention on Cluster Munitions is covered. If you want to take a look at the book, read the blurbs on the back cover. Guess how much I paid for it. Gents, ladies, I really appreciate your taking the time out of your schedules, and I hope you find the book worthy.
We've got some time for questions, and we actually planned on this. So, if you want to bring up one of these controversial subjects that Gary or I or Jamie raised, we can go into more depth. Betsy?
Well, not controversial, but I'm curious to what extent you approach this as a book of U.S. law of war versus international law of war,
yes,
and how much comparative work you did, and how you grappled with that.
I intended to make it an international book, but it just didn't work out that way. I'm an American. I have access to American sources. All of my experience in the courtroom and in the law of war has been American experience. And I just didn't have enough experience, enough expertise, enough sources to get international law of armed conflict, international humanitarian law. So I depend primarily for my foreign application on foreign cases. As you will see when you look at the table of cases, there are a number of cases, not only from the ICTY, but from Israel, of course, from the Netherlands, which has a very active IHL program, from the UK, of course, and other states. But it's primarily Israel and the UK, and of course the ICTY, ICR, from which I draw my foreign lessons. I do have some texts from foreign states in English, which I use, but there is no question this is a very heavily U.S.-weighted text. But I try to point out when there, for example, human rights on the battlefield. As we know, the U.S. position is no law of armed conflict, lex specialis on the battlefield. Human rights only apply when, and of course the European position is contrary, that they operate on the battlefield hand in hand. I cover that in the book, but that's one of the... I believe that human rights are making their way onto the American battlefield as well. And one day we will see it acknowledged. But as you suggest, it's very largely a U.S.-weighted textbook.
That might be one way to address one of Gary's points, and that's the concept of murder of an unlawful combatant. The law of armed conflict means a lot of things to a lot of people, and it could be the international law of war or law of armed conflict, or it could be a branch of domestic law. In fact, there's a great deal of military commissions jurisprudence that's just domestic jurisprudence. It comes from as far back as the Revolutionary War, you point out in the book, is a military commission that tried John Andre, but goes up through the Mexican-American War, through the Civil War. Military commissions were conducted by specific nations through the Philippines insurrection. The U.S. conducted them, but after World War II, Nuremberg is just the surface of the jurisprudence of the law of war after World War II. There's a great depth of, and Gary's done a lot of research in this area, of jurisprudence from the Allied nations as Allied nations individually trying people. So there's domestic law of war. A colleague of Gary's at West Point, Major Den, wrote a great law review article about this, the domestic law of war. It's worth reading and thinking about. Jamie, do you have anything to say?
The only thing I'll mention on the war crimes, I think there's one issue which is certainly an area where I think requires a little bit more development, the question of the nexus between the crime, the offence, and the conflict. Especially when you're looking at, one, what is the definition of the nexus? Where do we go with that? How linked must it be to the armed conflict? And you touch upon it with the international tribunals, but it is certainly a subject which I think merits further development when you're looking at these new types of sort of transnational conflicts that people keep referring to. Can you create a sort of nexus so that you would have a sort of traditional war crime, or are we talking about something completely different these days? And maybe the old terms are being abandoned in favour of something different.
Another question, ma'am?
I have sort of a multiple issue question. Did you go into the Goldstone report from the Gaza conflict, and what do you think about the growing UN debate that a country like Israel can't investigate itself properly because it's not independent from the military? Do you think that's something in the whole debate about universal jurisdiction?
I did not go into the Goldstone report. It came out too late. I could have pulled some stuff back, but I didn't. I only did that for the ICRC study. I do believe that a country can investigate, a military can investigate itself. And we have seen that in, for example, the Haditha case. Initially, terrible. But finally, we got some decent investigatory work from the Army's investigation of the Marine Corps' activities in Haditha. You may have seen on WikiLeaks a couple of weeks ago the videotape of the 2 helicopters that shot down 10 to 15 Iraqis, including 2 Reuters reporters. Well, I've examined the 1560 Army investigations that were conducted on the ground. There were 2 of them of that investigation, of that incident, and I found them to be comprehensive and complete, and I thought accurate in their assessment of the law of armed conflict and the outcomes. Well, we won't go into that more, but yes, I think that we can, because I have seen it done. Now, having conducted investigations as a military guy on the ground, I also know that those investigations can be warped to downplay the allegations of crimes. They can be biased in either not mentioning wrongful acts of, in our case, American soldiers or Marines, while emphasizing the potential wrongful acts of the enemy. But it can be done. But like most things on the battlefield, it requires close attention by the commander. I think any time you find a relaxation of leadership, let alone an absence of leadership, you're going to have trouble on the battlefield. In the military, when things go south, it can almost always be, I think Dick would agree with me, it could almost always be attributed to a failure of leadership or a failure of training, or both.
Gary's done a great deal of research in the area of war crimes and prosecutions, and he started with the Vietnam examples, where we made some real mistakes in terms of covering things up. The Americal Division's cover-up of My Lai is the best known example of that. But I'm convinced in looking at cases from the last couple of conflicts, and Gary cites a number of these. He's got a 2007 case from Iraq, Sergeant Giroux, I think it is. It's an Army case. It's in the book. That deals with this issue of whether or not a superior can or should cover up the offense and has an obligation to report. And so it's a constant thread of, speaking of historical threads, of emphasis in the law of armed conflict is sanctioning that conduct and making sure that it's properly investigated. But But there's another aspect to this, and that is that the law of armed conflict is mostly about treaties between states. And states take obligations from these treaties. And there's two obligations, and this also gets to the definition of war crime issue. There's two obligations that come from the Geneva Conventions. The first is to prosecute or extradite grave breaches. And those grave breaches are clearly identified. It's killing protected persons. It's willfully, wantonly destroying private property. It's what most people, if you ask them what's a war crime, they pretty much, they can identify those crimes as grave breaches. But there's a second obligation that's contained in the Geneva Conventions, and that's to take all measures necessary to suppress other violations of the law of war. So that's where I kind of disagree with some of the direction Gary takes on the war crimes issue. Although he makes his point in the war crimes chapter that there are a lot of other ways to suppress war crimes violations. There's administrative actions you can take. You could take what we call non-judicial punishment, letters of reprimand for minor violations. Is everything that's in here, or the Geneva Conventions, every time you don't do something that is a guideline in here, provide 3 hots and a cot to a detainee, basically, if you're violating this standards, not providing them a shower every day, but every other day, I'm taking fanciful examples out of the air, but there's that kind of descriptive standard in the Geneva Conventions for civilian internees, for detainees, for conduct on the battlefield that we don't really want to criminally sanction. Do we? I mean, we really, those violations of the law of war, I mean, technically they're transgressions of the nation's commitment in signing those treaties, are not things that should be labeled war crimes or prosecuted criminally. But the training, that there should be a feedback loop. Well, first of all, they should be investigated. Second, they should be identified and measures taken to prevent them from happening again. And finally, if there's malfeasance or misfeasance, it should be sanctioned. And within the U.S. military, I believe we do this pretty well. The second issue here that arises from this treaty obligation is the concept of complementarity. And that is that the nation who signed the treaty has the first responsibility to act. And if their courts are open and functioning, if they're doing the things that I've talked about in dealing with these issues, then there shouldn't be, in my view, and this is my personal view, there shouldn't be a supranational body, a group of unelected judges, and that's what you hear when for example, the ICC is debated in the Congress, shouldn't be deciding whether or not to prosecute an American soldier who has been investigated and his behavior's been corrected, or for prosecutorial discretion reasons that are the responsibility of that government, he has not been sanctioned. That decision shouldn't be second-guessed by somebody from another nation, and that's my personal view on it.
If I could just jump in for 2 seconds.
Sure.
I think when you're looking at the whole suppression of violations of IHL, I think you use the word initially, but the word serious sort of comes to mind. I think the practical reality is, and most references of the suppression of serious violations of IHL tend to refer to the guarantees and the protections in Common Article 3, and I think it's either Article 4 or Article 6 of AP2. And so the tribunals, to that extent, have looked more towards the serious violations and have not sought to criminalise the other sort of actions that you mentioned there. So I think the logic is going in the way you suggested. In terms of the complementarity, and that's why I'm not speaking on behalf of the ICRC here, but I don't think if you look at the questions of, for instance, the ICC and the question of complementarity, it's really a matter of sort of second guessing at that level. I think from what we've seen from practice so far from the International Criminal Court, the standard is fairly high in terms of at what point will they decide to step in terms of willingness and ability of the state to prosecute individuals. And of course, the ICC is limited to, unless you get a Security Council resolution, to those who have signed up to it. So those considerations need not worry too many states that have not signed up to it. I think the bigger issue comes down to those that have not signed up to the ICC statute, leaving aside any specific countries, but going back to the grave breaches responsibility on the extradition. Either you prosecute or you extradite. What enforcement mechanisms are there in place these days to ensure that where a state fails in its obligations to prosecute a grave breach, that state can be forced into a position of extraditing to another state for prosecution? I think that's a big question as well that needs to be addressed at some point, which doesn't go straight to your book, but is more linked to the complementarity argument.
Although Gary does have the prosecutor extradite requirement in his book, and it makes it pretty clear that that's a responsibility. Other questions? Sir.
A comment and a question. And for full disclosure, I was actually in Professor Solis' class last semester where he test ran some of his chapters, so we had the distinct honor of being test subjects for this book. And my comment is that it was a good book then, it's a good book now, because although I'm a foreign lawyer, a Canadian lawyer, I appreciated the fact that it had a lot of American case studies, Yamashita, the Medina case, and even more the special operations that are happening in Iraq, and taking texts from the various books that have been published by former officers who have been in Iraq and Afghanistan and so forth. But my question to Professor Solis and the panel is, in terms of customary international humanitarian law, if you can comment on the development, but more so, what are the actual indices or the where can you find evidence of it? Because there's been a lot of controversy of using field manuals as suggesting that it is now customary international law to do this or that or whatever, and especially with the coming of the new U.S. manual.
Good question, TJ. I think that, first, my gushing about the ICRC, it may be as a result of my overreaction at West Point, where West Pointers are always saying, what the hell do we need these guys on the battlefield for? All they do is get in. And I try to make the point that, no, they are the honest brokers. They are the canary in the mine on the law of armed conflict. We have to have the ICRC. It's a vital job that they carry out, along with other NGOs. But I think the ICRC's study on customary law may go too far, in some cases, on what is customary law. So what are the indicia? The traditional indicia, of course, are state practice and opinio juris. And the problem, of course, is we have no bright line test for either of those, or for opinio juris. So it's very hard to say what is customary law. What we can say is that a great deal of customary law has been codified now, especially with AP1. It has codified so much customary law. It's not all there, though. So, for example, we still don't have military necessity anywhere. That's still entirely customary. So, what are the indicia of customary law? All we can do is look to state practice. And that state practice, for example, is evidenced in the international response to the attacks on the U.S. at 9/11, where we immediately attacked Afghanistan, a country which had not, as far as we knew, had any direct participation in 9/11. But it was an act that was approved by the international community. It seems to me that we see customary law forming very quickly on that point. Very quickly. And so I'm impressed that customary law still exists. I believe it still has a valuable function, and I believe it is still functioning, but I don't think it has the vitality that it had, say, 50 years ago.
There's a U.S. position on this that's available on the State Department website. It's been termed the Kellenberger letter to Dr. Kellenberger, the president of the ICRC. It was drafted by both Mr. Haynes and Mr. Bellinger, the former general counsels of DOD and DOS, respectively, and it hasn't been withdrawn like the U memos or other in this administration. And it describes what the U.S. position is on customary international law. But the gist of it is that the density of practice in the CIL study by the ICRC is the biggest question. Rather than go to manuals, there's been a lot of practice. I mean, battlefield practice that could have been better documented in that manual. In that study. And opinio juris is the other key piece that is not well developed. But I agree with Gary that there's still customary international law developing, and one of my personal goals is I'd like to see AP1 nailed down a little bit, because I don't see any chance that AP1 would be ratified by the U.S. in the near future. There's an awful lot of goodness in AP1. Let me give you an example. It's here in Change 1 of the Law of Land Warfare. This book, Gary said this is 60 years old. It's July 1956. But in July of 1976, before the 77 protocols, this change adopted the definition of military objective, the proportionality tests that were contained within Additional Protocol 1. So there's some evidence, and I think these manuals, particularly one as authoritative as the Army Field Manual, provides some evidence that needs to be tested against practice in customary international law. And if we can't get treaties ratified, then customary international law has to be developed some way. So that's one way to do it.
I just tend to agree with what you're saying. The letter we refer to as the Haynes-Bellinger letter, and for the record, it's on our website as well, plus the ICLC's response to that. And there were questions on methodology. The ICLC at this stage is updating the study, so hopefully later this year there'll be some further information. We're working with the British Red Cross and a number of states and experts to update it. But just for the record, there's extensive practice, extensive opinion juris. There are references to manuals, and one or two manuals have been referred to on a regular basis as being, how can you refer to this particular manual? But I think for the most part, with 150 experts having been consulted over a 10-year process, and most experts consulted throughout the process, for the most part, and there are, of course, there'll always be certain rules that individuals will question in terms of their standing. For the most part, the study has been taken on board as a relevant and important study as to custom, and I think set a sort of fairly good standard as to the debate, discussions, and seeing the strength of customary law evolve.
The lady in pink had her hand. Oh, ma'am.
It was just the bigger person in front of me. I haven't read your book, so I may be asking those questions. I haven't read it yet. The first one is from a historical perspective. Do you also review the jurisprudence coming out of the Tokyo War Crimes Tribunal? You talked about Nuremberg, but what about the Tokyo War Trial? And then secondly, in the discussion of the war crimes, we all know that the Treaty of Rome couldn't get to international agreement with respect to the war of aggression. And there have been attempts to try to flesh that out, especially when certain states called for a first strike use of nuclear weapons as being evidence of the war of aggression. Did your book also explore that particular issue?
No and no. First, the Tokyo IMT. In my view, the Tokyo IMT's opinion is so riven with dissension. As you know, Judge Powell, for example, dissented entirely from the entire thing, and there were separate opinions. And the conduct of the Australian Judge Webb and the American prosecutor were so suspect. And the thumb of General MacArthur on the proceedings was, in my view, so apparent that I find the Tokyo War Crimes Trial suspect. So, no, I don't think there was anything new in the Tokyo IMT that merited a fresh look. So I don't say much about the Tokyo IMT, although of course I do discuss it in very general terms. As for the Rome Treaty, no, I don't go into the issue of the issue that you mentioned. I I wonder if we're not seeing a glacial move on the U.S. part toward an accommodation with the ICC. I mean, we all know about the steps that have been taken, our failure to object to some of the actions of the ICC and the UN, are now sending claiming observer status for the proceedings at the ICC. So I wonder if we're not moving that way, just as we are in effect bound by Additional Protocol 1. Although we've not ratified Additional Protocol 1, I try to point out in the book that we are bound by AP1 by now. We have, at least once, we have said that 65% of AP1 represents, I know I'm going beyond your question, I'm sorry. Anyway, I think we are essentially bound by AP1, whether we have ratified or not. I think we are moving towards an accommodation with the Rome Treaty as well. That'll take years and years, of course, but I think at least we're looking in that direction now.
I'd commend.
Not a good answer to your question.
I'd commend Professor Dean Coe's remarks at ASIL to you on the ICC. He stated the latest U.S. position on that. Personally, I think the crime of aggression is another one of those examples of a mixture of jus ad bellum and jus in bello that's troubling, particularly when you look at the crossover with the modification of the UN Charter that comes with the definition of the crime of aggression. Essentially, it takes the UN Security Council's responsibility of defining aggression or breaches of the peace out of the picture, which essentially turns the UN Charter regime on its head. So it's troublesome to me personally in a couple of ways. That's a great kind of topic that a professor can introduce in a class and really to illustrate jus in bello and jus ad bellum principles that really might be worthwhile for putting in the next edition.
The only tag on I have there is a question back to you is, to what extent is it actually in the ICC's interest to have the crime of aggression effectively defined as part of its mandate? Because it is such a politicised issue that it might create more problems for the ICC in the long term than it would if it weren't in the statute. So in my personal capacity, of course.
A U.S. ship, I believe it was the Vincent, shot down a civilian Iranian airliner. And the circumstances I remember, of course, there was no active war. I mean, there was no war going on. I believe the U.S. ship was in Iranian territory. And it was also rising, so there was no threat. Nothing really came out of that. But is there any law that applies to an act like that and any retribution from that law? It sounds like manslaughter to me.
Well, it wasn't a war crime because there was no armed conflict in progress. So what was it? Yes, you're correct. I would agree with you that Captain Will Rogers of the USS Vincennes didn't have full control of his combat operations center at that time. And when you listen to the tapes of what was going on there, it was cacophony. And you had Seaman First and Seaman Third who were yelling, "He's turning our way, he's coming in for an attack," and so on and so forth. And it didn't seem as though they had the control that you would expect of in a ship with weaponry of that kind. And I think it is probably agreed, certainly there's a general consensus among most naval officers who've written about it, that Captain Rogers fired prematurely. Not prematurely, he just simply should not have fired. And of course, as we know, the result was an Iranian Airbus with a full complement of crew and passengers was shot down, all hands lost. So, what was that? I don't know. What was that? Was that a crime under Iranian law, or was it an offense that was at least justiciable under Iranian law? Certainly, we were not going to try him. And by the way, the gunnery officer on the Vincennes, on the return of that, after that cruise was completed, received a Navy Commendation Medal for his performance throughout the cruise. And as you may also know, there was a bomb placed under Captain Rogers' SUV, and his wife and children were in it when it went off, but it was not sufficiently strong to kill anybody. But somebody tried to get back at Captain Rogers in an extrajudicial manner. So I don't know. It wasn't a violation of the law of war. It may have been a domestic event for Iran. We certainly weren't going to try him.
There's a couple of illustrations from the book that go to your question. One is the question Gary just asked about whether or not it was an armed conflict. I don't know as much about the situation as Gary does, or as you might, sir. But that question of whether or not it's an armed conflict and the laws of armed conflict apply to this use of military force is certainly, at least in academic circles, a question worth asking about the swift boat attacks by Iranian militias against boats in the Gulf at that time, whether or not that made it into an armed conflict, the apparent squawking of a Iranian jet at or about the same time as the Airbus, and then the second issue that's in the book that's really worth considering, that it comes from that, is the targeting responsibilities of the commander and what he knew and when he knew it, and then taking as a bookend of that analysis what the Grave Breach Standard is. And this gets back partly to your Goldstone question, which is that the Grave Breach Standard for this type of attack is whether or not that the commander at the time, based on the information he had available to him, knew that it would be that there would be an excessive loss of life as compared to the concrete and direct military advantage gained. Actual knowledge, willful and wanton, is the language of the Grave Breach. Okay, so the standard that I would say that would be applied to a commander in that kind of situation is first based on what he knew at the time. You can't really engage in 20/20 hindsight, and a number of the reservations of additional Protocol 1 by our allies make this point very clear. Mm-hmm. And second, it's the Grave Breach Standard if you're going to sanction that conduct.
Can we have a Coke?
I think there's some confusion between actual knowledge and willful and wanton. Certainly in domestic law, willful and wanton is a lesser standard than actual knowledge.
Well, and it uses, in much discussion of this, it says tantamount to actual knowledge. So it blurs it even further. But again, that's a much higher standard than what either Goldstone applied to the Israeli actions, or I would submit would be applied to the commander's action in this circumstance. But that's a good point, sir. There is a difference between those two standards, although both languages are used. Last question, sir.
Okay. With respect to the Office of Legal Counsel torture memos, does your book discuss the process by which the memo was drafted and approved, particularly whether the drafter adequately consulted relevant materials and experts, and in light of the fact that it was withdrawn, do you think the lawyers who drafted and approved should have been subject to discipline or referred to some further investigation, bar association or otherwise?
No, sir, I did not go into how the 4 top-secret CIA memos came to be. I felt that res ipsa, they speak for themselves. And I suspect that you have some knowledge as to how they came to be, but I did not look at that, and to tell you the truth, I didn't care. And as to whether or not the lawyers who participated in their writing should be disciplined, that's out of my lane. I have a personal opinion on it, but I'm not an expert in that regard. So, not a very good answer to your question either, I'm afraid. I'm sorry.
Well, that's great. I'm sure there are more questions, and I'm sure that Gary will hang around and sell sell books and sign books and answer questions. And please help yourself to refreshment, courtesy of the ICRC. And thanks very much to our great panel.